Welcome. My name is Steve Hattenbach. I am currently the Forest Supervisor on the Cibola National Forest and National Grasslands out of Albuquerque, New Mexico. I'm going to be giving you a presentation today on agency and personal liability related to prescribed fire and wildfire and investigations related to those issues. I'm giving you this presentation today as the Forest Supervisor. But my professional background includes 18 years of legal practice. I'm still a licensed attorney and worked for state, local, and federal government, including a decade of work for the USDA Office of General Counsel, where I represented Forest Service on many of the issues that I'll talk about today. I am not your attorney, though. That is a caveat that I've entered into the first slide of this presentation, that for legal issues that you face related to liability or investigation, you must consult your local agency counsel, your personal liability carrier. The facts always change the end result of any legal issue. So what I'm presenting today are general rulings that courts have entered on specific historical factual situations. Your experience may vary if you personally face some of these issues. I'm going to focus on 4 main topics today. These are the questions I am usually asked about these issues. Number 1, can I be sued if I'm an agency administrator on a prescribed fire or a wildfire? Will the government defend me if I am sued? And can I be held personally liable for damages as a result of a lawsuit or a claim? And then finally, should I have professional liability insurance? The answers to these questions, as you will see today, are yes, you can be sued, but in most cases, the government does defend you. In most cases, the government is liable, not the individual employee. And, well, it's your personal opinion whether you need liability insurance, but I will give you some pros and cons on those. Now, first, I am going to discuss investigations. This is not a question that people usually ask me. People want to know if they can be held liable. But here's why we're going to spend time discussing investigations. You will probably be involved in an investigation related to a wildfire or a prescribed fire during your career. The number of escapes of prescribed fire are statistically very low. Usually in a live audience, we ask the group, and maybe 1 or 2 people raise their hands having dealt with an escape of a prescribed fire. Estimates I've heard are around 1% of prescribed fires result in an escape. But over the course of your career, odds are you will deal with this. When you're in a live audience and you ask the question, have you ever been involved in a lawsuit related to an escape? Very few people raise their hands. It's statistically unlikely, yet possible that it does happen, but it's only a portion of that 1% of escapes that usually result in some sort of claims or litigation. I will also discuss personal liability. And as I've noted here on the slide, and I'm pointing with my pointer, there is a rare possibility that you might be personally sued. It does happen. It is still statistically very, very rare. So I just want to put this into context for you, that what you need to be concerned about as a professional, as an agency administrator signing an ignition authorization for a prescribed fire, is really the investigation part, which we will go over the importance of documentation for that investigation. That is the most likely action you'll be involved in. If you're one of the unlucky few, you might be involved in litigation. Now, there are different types of reviews and investigations that happen related to prescribed fire and wildfire. And I'm going to talk a little bit about prescribed fire reviews. The goal of a review is mostly learning, improving performance. This can be as simple as an informal after-action review, sitting on the tailgate of the truck after a fire and talking about what went well and not. It could be a more formal lesson learned review. If there is a bad outcome, you may end up with a facilitated learning analysis, looking at serious injury or fatality in a prescribed fire. I've included in this presentation a link to a video that talks about the purpose of a facilitated learning analysis and the outcome. Then, of course, there are declared wildfire reviews. If you have an escape and declare prescribed fire to be a wildfire, there's always a review conducted about what went well and what went wrong to cause that to happen. All those declared wildfire reviews are posted on the Wildland Fire Lessons Learned Center. I'm pointing at the link here with my green pointer. I encourage you to go check those out. If you're aware of a prescribed fire that escaped, either on your unit that you're managing or on a neighboring unit, there are many lessons to be learned from those. Now, we may have an audience here composed of both Forest Service, Bureau of Land Management, Fish and Wildlife Service. Each agency may use a slightly different description of their learning reviews after an incident. I encourage you to look at your red book, your interagency fire guide. Chapter 18 explains the different types of reviews that each agency conducts to learn and improve performance when there's an escape, or even when everything goes well. An after-action review may be worthwhile. I want to differentiate a review from an investigation. As I said in the last slide, I'll go back. A prescribed fire review, the goal is learning and improving performance. An investigation, the focus is usually on fault, liability, violations of law, regulation, or policy. So one takeaway from this presentation is keep your ears open if you have a bad outcome and know whether you are involved in a review, which is a learning opportunity, or an investigation, which is a more serious matter to determine fault, violations, and liability. There are many different types of investigations, and I have lumped them into 3 different types for you. First one is administrative. There could be an investigation of misconduct, a personnel or disciplinary related investigation related to a prescribed fire escape. If there is a fatality during a wildfire, law requires the Office of Inspector General, an independent third-party agency, to conduct an investigation. If you'd like to see one of those, I'm pointing to the Kramer Fire Summary. That is a link that would take you to one of the first investigations conducted for a wildfire fatality. OSHA, Occupational Health and Safety Administration, also conducts their own investigation about compliance with workplace safety regulations. That's relatively uncommon, but is generally required when there is a workplace fatality. Those are administrative investigations. There are also civil investigations. If there's a tort claim filed against the government related to a prescribed fire you were involved in, there will be an internal investigation to determine whether there is some negligence or liability on the government's part. So you will be asked many questions during that investigation if you are involved. There's also the potential of a claim by the government against an employee. This is exceedingly rare, I'll give you an example. Let's say you're joyriding in your government rig and total it. There are some circumstances where the government may come after you for the cost of that government equipment if you're acting recklessly or intentionally. Finally, there are criminal investigations. How do you know when you're involved in a criminal investigation? Well, usually you're going to have some form of a Miranda warning given to you that anything you say can and will be used against you in a court of law. And you've all seen that on TV. So, perk up your ear, and if that's what you hear, yes, you're involved in a criminal investigation at that point. So those are three general types. Again, there are probably others out there, but these are the most common that you might see in a prescribed fire that has a bad outcome. Now, if there's one thing to take away from this section of the presentation, is that documentation is your friend in any investigation or liability situation. Lawyers often say, unless you can prove it, it didn't happen. Documentation can include hard copy documents, electronic records, email on your phone, voicemails. It's important to preserve key documentation for future investigations and liability issues. And one thing your counsel will be concerned about here is potential destruction or loss of records. Okay, there is a expectation and requirement for a potentially liable party to retain important records for any liability claim. That is the purpose for your counsel to issue what's called a litigation hold. It's a letter from your counsel that will say, please do not destroy or get rid of any key documentation or evidence related to this investigation or claim. If you do destroy those documents, you can be stuck with what's called a negative inference by the court, which basically means the court will assume that the evidence was not in your favor. So you want to avoid that. So it's important to retain your documentation. And what does that mean in the context of prescribed fire? Well, the key document is your burn plan. And any amendment to your burn plan, particularly the basis for why did you deviate from the original burn plan, that amendment, and then your ignition authorization, all those key forms that you fill out to go ahead and ignite and note that you've met all the required conditions of the burn plan. Those are key documents that you want to keep if you end up with a bad outcome with a prescribed fire. Now, here's another key point that I want you to take away from this portion of the presentation. During investigations, you should tell the truth. Talk about you. You individually should always tell the truth, the whole truth, and nothing but the truth. Why? Because there's potential criminal liability for lying during a federal investigation. I've listed here on this slide a number of statutes that might be applicable. False statements in a criminal proceeding, obstruction of proceedings before a federal department, etc. This is the most common criminal violation that individuals are subject to. And you only need to watch the news over the past few years to see all the investigations that were conducted regarding Russian tampering in the election. And the most common violation all those individuals were prosecuted for was lying under oath, failing to tell the truth to an investigating officer. And here is an example from the fire context. During the 30-mile fire, which was a very famous incident that resulted in a number of investigations, administrative, civil, and criminal. A number of charges were brought against the incident commander. The findings of those investigations is that numerous safety procedures were violated, but in the end, all the various charges and claims were dropped, and ultimately, the only thing that the incident commander pled guilty to was an instance of lying to investigators. So it's very important. I'm going to repeat it again. In any investigation, tell the truth, the whole truth, and nothing but the truth. Don't tell little white lies or edit out facts. That will get you in trouble quicker than the truth anytime. Now, if you're involved in a prescribed fire that has a bad outcome, there will be media inquiries. There may be a request for documents or other evidence from third parties who are injured. So just a quick point about media relations in a crisis. You're probably not the person to talk to the media. Generally, you want to let your public affairs professionals handle these kinds of inquiries. You may find yourself with a microphone stuck in your face, asking you what happened and how. Generally, federal employees are not obligated to speak to the media on impromptu questions. It is okay to refer those to the professionals who answer those. You will likely end up receiving FOIAs, Freedom of Information Act requests from outside parties wanting to build their claim against the government. Work with your specialist staff. They know what can be released and not. Don't do this alone. You have people to help. And finally, subpoenas. A subpoena is a process whereby a court orders you to come and testify. And very often, government employees are dragged into litigation between two private parties who are suing each other related to a matter. For example, maybe it was a state or county burn, and you were just there as a resource to help out. Well, federal government doesn't necessarily give up its resources to testify in those private party litigations. What we use is called the TUI regs. I've given the citations on slide 8 here of both the Department of Agricultural regulations for Forest Service and Department of Interior regulations for you Interior folks. It limits the appearance of a federal employee as a witness unless they are cleared both by their counsel and their supervisory chain to go testify. If you get one of these subpoenas, all you need to do is talk to your supervisor and your agency counsel, and they will take it from there and decide if under these regulations you're forced to testify. So to hit a few key points, I want you to know from this portion of the presentation. Know the difference between an investigation and a review. Investigations look towards liability, violation of law, reg, or policy, and fault. Reviews are learning exercises to improve performance. Remember to keep your documentation and maintain it. It is your friend. It will help you in all investigations and liability issues. And very importantly, tell the truth, always. It's always easier to defend a bad fact than a white lie. So that is the end of this portion on investigations and reviews. Now I'd like to talk to you about agency liability. And I am talking to you about agency liability first because generally, if the agency is liable, then the individual employee is not personally liable. I'm going to explain that more as we go along. But in general, it's either one or the other. Either the agency is liable or the individual. And so I want you to know the general circumstances where an agency might be liable if there's a bad outcome. So, you work for the federal government in some capacity, and the United States government, on the supremacy clause of the U.S. Constitution, federal law is supreme over conflicting state and local law. That's a fancy explanation for, as a federal employee, sometimes you can do things that would otherwise be prohibited under state law. So here are some examples. We can and do burn during a local burn ban. Those state and local burn bans conflicted if the federal agency decides to conduct a burn, and we can burn during those events. We do occasionally. Another good example of actions a federal employee may take that would otherwise conflict with state and local law, Code 3 driving for emergency response. That's pretty rare for an agency administrator, but some of your law enforcement officers and fire staff may turn on their sirens and lights and drive Code 3. I have an example case here to talk with you about where it's State of Texas versus Carly, where a Fish and Wildlife Service employee negligently, unknowingly, trespassed across 2 ranches while they were doing an inventory. And the rancher was very upset, claimed they were on private land, got the county attorney to file criminal trespass charges against the individual federal employee. And under the Supremacy Clause, the United States attorney just removed that to federal court and dismissed it. As a federal employee, they were not subject to those state trespass laws. They were acting within the scope of their duties. We'll talk about that more. And they could not be punished under that state criminal law. Now, I often get this question, what are the limits of the Supremacy Clause as a federal employee? What can I do that would otherwise violate state law? And I want to give you a caveat here. The United States wants you to comply with state and local traffic laws. Those are not exempted. Just because you're driving your government rig doesn't mean you can ignore stoplights and stop signs. You still have to comply with those. So there are some categories of laws which there are general expectations of compliance. But in the prescribed fire context, you have some examples here where the federal government may take actions that might otherwise be prohibited by state law and will not result in personal liability for you. That's the case law example here. So the Supremacy Clause protects you for acts within the scope of your duties, not an intentional criminal act. And so here are some examples which are not prescribed fires, which are called arson. If you start a fire without a burn plan, you're engaged in an act of arson, not a prescribed fire. So here we have an example of the Hayman fire where a forestry tech allegedly was burning a love letter during fire restrictions. She was on patrol at the time. And not only was that act not within the scope of her duties, she was supposed to be stopping campfires, not starting them, but it was determined to be a criminal act and held liable there. Similar in U.S. versus Newman, we had a Forest Service employee starting fires on the forest, and that was a criminal act. So again, if you have a burn plan, you're engaging in a prescribed fire. If you're just randomly setting fires, well, then that's an act of arson, and that's not only is it not within the scope of your duties, but the Supremacy Clause will not protect you in that instance. I'm going to circle back to scope of duties later and give you some more detail on that. Now, besides the Supremacy Clause, there's another reason the United States might not be held liable, and that is called sovereign immunity. In general, you cannot sue a government for monetary damages unless they consent to suit. Well, the United States has consented to be sued with what's called the Federal Tort Claims Act. Most of you are probably familiar with that. It states the U.S. can be liable for injuries from the negligence of its employees committed in the course of performance of their duties. So I've underlined these terms. Negligence, we're going to talk about what that meaning is later, and course of performance of duties, the scope of your duties will be a topic we'll talk about in some detail. But here's a great takeaway from this part of the presentation. The last bullet, federal employees have absolute immunity from civil suit for negligent acts or omissions within their scope of employment. So what that means is if you are negligent on the job and within the scope of your duties, Only the government can be held liable. You cannot be personally sued. Why would the government do this? As a general policy matter, we employ humans, and we know that humans make mistakes. And in general, the employer is responsible for the mistakes of their employees because they pay them to do a job. We are all hired and paid to conduct prescribed fires, and the government knows very well that during the course of that, there will be occasional mistakes. And just as a general policy, government employees are not held liable for those actions. We're conducting it on behalf of the government, so it's the government that is held liable. So that absolute immunity should give you a great sigh of relief that if you make a simple mistake on the job, in general, you are immune and the government is held liable. So even though there is a waiver of sovereign immunity, there must still be some negligence for the United States to be held liable. And I have an example here. The phrase is, bad things can happen without negligence. And the second bullet point is an example from my own forest. The Redondo prescribed fire escaped, turned into a type 1 complex of fires. Very costly, extended incident that after the facilitated learning analysis reviewed it, found the principal causes for that escape was exceedingly high winds that were not predicted in the weather forecast, gusting more than 20 miles per hour over predicted winds, and the criminal actions of a third party. There appeared to have been an arsonist going around setting fires outside the prescribed fire perimeter, which all led to the effect on resources and the escape of that fire. So in an example like that, the United States might say, doesn't matter if there were damages, it's an act of God or a third party, even the government's not liable. Finally, there's another reason why the government might not be held liable if there's a bad outcome for prescribed fire. There is no government liability for an act or omission of an employee who is exercising due care and performing a discretionary function. Well, what does that legal language mean? It means that, particularly in the prescribed fire and wildfire context, these are fluid, dynamic situations that often call for exercise of professional judgment, where there's no clear rule or policy to follow. And in those instances where you're really exercising discretionary judgment and action, the government's generally immune for those actions. I'm going to give you some examples of this in the wildfire context. So this first bullet point is a case where a backfire was lit to check a fire, and some private property was damaged with the lighting of that backfire. Even though it was successful at holding the fire, some property was damaged. Well, this court in Montana found that that's a discretionary function. That really is an emergency response situation where you're choosing the best course of action, where there's no clear guidance or policy that mandates what you do, and found that the government could not be held liable in that situation. The next bullet point talks about suppression actions during a wildfire. This involved, well, maybe some people are getting a little happy with their dozer lines, and they damaged quite a bit of private land, ranch land. The court dismissed a tort claim related for that damage to private property because they found that emergency response and where they put those lines, although it may damage some private land, was a discretionary function. The government was not held liable. And finally, probably very important for many people, in this McDougall case in Oregon, a decision was made by the agency administrator whether to manage a natural ignition as a prescribed natural fire, which was the appropriate term at the time, whether to let that fire burn as a prescribed natural fire for resource benefits or engage in full suppression. The decision was made to let it burn. It did eventually result in private property damage. However, the court here in Oregon found that that was a discretionary function, whether we engage in full suppression or manage a fire for resource benefit. So those are some examples of where the discretionary function exception would mean the government is not liable, even though there may be some damage to private property. Now let's talk about it in the context of prescribed fire. There are very few cases on this. There have been mixed results. There have been a few cases here where the exemption has been applied to an escape prescribed fire and the government held to not be liable in those cases. That's the Thune and Taylor case at the top of slide 16. We have a mixed result here in the Ruffino case where the court didn't decide one way or the other. They said, well, the exception applies, but we're going to send it back to the trial court for more fact-finding. There are some disturbing questions about compliance with policy and what the burn boss is doing here. And finally, we have a case where the court said the discretionary function exemption does not apply. That case came out of Florida, and I'm going to point you to some of the quotes from the case that probably led to the court's ruling finding that the government was liable. Forest Service employees in that case admitted they had not created a sufficient burn plan. They also said they were using aerial ignition without an aerial ignition operation hazard analysis, which was required. Multiple really damaging admissions by the employees about really not following appropriate law, reg, or policy. I'm going to take you back to slide 14 and point out at the bottom, for the discretionary function exemption to apply, the action must be discretionary. If an action is required by law or regulation or burn plan, it's not really discretionary. You're just not following your burn plan or law, reg, and policy. And that probably led to the result in this Florida case on slide 16. Now I'm going to end with this portion of the presentation on bad facts make bad law. It's a saying you might hear attorneys say, and I think that Florida case was one example of it. You can still lose a case you should otherwise win. It's happened to me. The United States may decide to settle a case even when the law is on their side. They don't believe that negligence occurred because there may be factors that an agency counsel would consider very risky if it was taken to trial or in front of a jury. And that could include very sympathetic plaintiffs, a very unsympathetic judge. Fatalities are always a wild card. And I'm going to give you an example here from Region 3 of the Forest Service off the Kaibab National Forest. The Green Base prescribed fire was conducted on the Kaibab in 2016. An unexpected inversion caused very heavy smoke to settle on Interstate 40. And even though procedures were followed to warn motorists with signboards, etc., multiple fatality accidents occurred on Interstate 40 because of the smoke, reduced visibility, and excessive speed. Now, the agency's position in that litigation was that all elements of the burn plan were met. Everything was properly documented. All conditions in the burn plan were met. We were within conditions. Wind speed and direction and dispersion index were all within appropriate parameters, and then it was really this unforeseen weather event, an act of God, that was the contributing factor to these fatalities. Now the agency settled that. As far as I know, the contents of that settlement are confidential, so I won't get into the details, but this is a great example of where you may feel that you've done everything right, but I myself as a counsel would be very hesitant to take a multiple fatality case to a jury and say, government doesn't own anything. That's where you start to find juries and courts start to find exceptions in the law and find a way to hold you liable. And sometimes it's just better to settle that case and walk away with a minimal loss rather than a major verdict against you. This is frustrating for individuals that are involved. There are individuals involved in this fire that I talked with that feel frustrated. They feel like they did everything right, and they feel somehow betrayed that the government, is settling this case. Feel as if it's some sort of admission of fault, and it's just not. Litigation is uncertain. The results are, and sometimes just bad facts make bad law, and you have to settle a case rather than take it all the way. So I'm going to summarize a few key points from this section on agency liability. Generally, if the agency is liable, the individual employee is not. There is absolute immunity for negligent acts as a government employee. The government is liable for your negligence. Federal employee has absolute immunity. There are many exceptions to the liability of the government where the United States might not be liable even though there are damages. So it's important in any communication with the public that you don't promise that the government will reimburse them for damages from an escape prescribed fire, because there are many reasons that the government itself and you may not be held liable. And then finally, results of litigation are always uncertain. Even if you feel you did everything right, the government may just have to settle the case because bad facts make bad law. Now I'm going to talk about personal liability. This is what everyone really wants to know about. I'm talking about personal liability after agency liability again, because in most instances the agency is liable, not the individual. There are exceptions to the Federal Tort Claims Act where the United States will not be held liable, and liability may rest with an individual employee. And so here are some examples. Actions taken outside the scope of your duties. We're going to talk about that underlined phrase more. Damages from reckless conduct or criminal acts. You may remember the examples of arson I talked about previously, where individuals were setting fires without a burn plan. Okay, those are criminal acts. Violation of constitutional rights, also called Bivens actions, that usually comes up in the law enforcement context with unreasonable search and seizure, false imprisonment. Pretty unheard of in the prescribed fire context. I have no example of that in prescribed fire. If you take a look at the federal statute, the citation is here on slide 19. There are 14 listed criminal offenses or tortious conduct that are listed by name that the government will not be liable for. And to give you an example, assault, battery, false imprisonment, libel, slander, these are pretty easy to recognize when you're engaged in these, when you might be personally liable and the government not. So I'm going to talk about the meaning of negligence. Again, under the Federal Tort Claims Act, negligence, the liability rests with the government, but a federal employee who is reckless or intentional in their conduct that causes harm can be held personally liable. So what does that mean? I'm going to give you some examples here from the motor vehicle context. And I will give you examples from driving government vehicles because statistically that is the most likely fact scenario you will be involved in as a government employee. Driving is still statistically the most dangerous thing we do, both in wildfire, prescribed fire, and in our daily lives for the most part. So the meaning of negligence, those actions that the government is liable for and not the employee, is failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. Well, what does that mean? Think about a common motor vehicle accident. Let's use an example. You're attending PFTC and you are excited about going out to burn with the group, and in your excitement you're distracted and you accidentally run over someone in the parking lot as you're leaving. It was an accident. It was inattention, distraction. It would result in significant injuries to the individual, certainly negligent. In that case, the government would be liable. That's a classic tort claim instance where you're driving a government rig on government time and injure someone. You may hear about gross negligence, which is called extreme carelessness or severe degree of negligence. This is the behavior that you would react to by saying, "What were you thinking? It was a really dumb idea." An example of this, many states have passed state laws that have established texting while driving as gross negligence. By statute, that distracted driving is gross negligence. Why would they do that? Because under gross negligence, you can get exemplary damages, punitive damages for conduct. And so, same fact scenario I gave you earlier, you're driving through the parking lot in your government rig to a prescribed fire with a prescribed fire training center, and you're texting in your excitement, which violates federal policy. You know you're not supposed to be texting while driving on a government rig. There's a executive order on it. There are department policies prohibiting it. And but say in the state you're in, it's classified as gross negligence. Same result, someone could get seriously injured, but yet it's still negligence. And under the tort claim, the government would be liable. Federal Tort Claims Act can include negligent actions that otherwise violate law, regulation, or policy if they're simple negligence. Recklessness. This is not covered by the Federal Tort Claims Act. I will go back one slide. Damage from reckless conduct is not covered under the Federal Tort Claims Act. So what are examples of recklessness? You have to consciously accept a level of risk to be reckless. It's a willful or wanton conduct. You don't accidentally become reckless. Sometimes by statute, driving more than 25 miles an hour over the speed limit is considered reckless. You generally don't accidentally exceed the speed limit that much. You know you're going a lot faster than you should be. Drag racing. Daring someone to drive while blindfolded. You may not intend to hurt someone, but good odds if you're doing that, you could have a bad result. It's wanton or willful conduct that shows a disregard for the health or safety of others. So in this example, let's say in the same parking lot, you're driving to the same prescribed fire and someone dares you to drive through blindfolded. You know that's a bad idea. You know someone could get hurt. That's clearly reckless. The government's not going to defend you in that kind of situation. Same fact scenario talking about intent. Intent means that you intended the action and the result. So in this circumstance, it would be seeing the pedestrian walking through the parking lot and intentionally, accelerating while saying, "I'm going to run you over. I intend to do you harm." Okay, that is intent, and the government's not going to defend you on that kind of conduct. Now I'm going to talk about scope of employment. To be covered under the Federal Tort Claims Act, you must be within the scope of employment. If you're outside the scope of employment, the government may not defend you. I'm going to give you some examples of how broad scope of employment is and what is covered. This is determined by state law, so it could vary from state to state. United States Attorney's Office or your agency counsel will look at state law to decide whether you're within the scope of your employment or not. But the principal questions I've outlined here, and I'll point to, were you furthering your employer's interest or your own? Is this the kind of action people in your position description in your job do commonly? What was the extent of departure from normal methods, and whether the employer could reasonably expect that to happen? Importantly, actions within the scope of your employment can still include a violation of a direct order, rules, or policies if it's furthering the interests of the employer at the time. So back to my texting while driving example, there are clear policies against that, from presidential executive orders to department policies. Yet the employer knows very well people will violate that policy routinely, and if you're driving on government time for a government purpose and texting, that's still going to be determined to be within the scope of the employment. You may still end up with disciplinary action for that, but the liability would rest with the government for any damages. So here are some examples. I will tell you that I have absolutely no examples from prescribed fire situation. I'm not aware of any litigated case related to scope of employment and prescribed fire. In fact, even in the wildfire context, these are unheard of. So instead, I'm going to give you some motor vehicle examples because, again, that's the most likely situation you'll be personally involved in. First, I'll start with a gross negligence example. What if you leave on fire assignment and you forget to ensure anyone waters the government livestock that you're normally responsible for, the horses and mules? And while you're gone for 2 weeks, it's 100-degree heat, and the water system breaks down, and all the animals die. Is that intentional? Is it reckless? Is it negligent, gross negligence? In this case, the agency found that it was gross negligence and would be within the scope of duties of the employee, even though they might be disciplined for that and punished in various ways. The actions were gross negligence, not intentional. What if you're off duty or at lunch and you drive to lunch, drive home on an errand? Would you be within the scope of your employment on a normal workday? I would expect the agency to deny that. And in this case I have on slide 22, Fowler versus U.S., the agency did deny that. Fowler was working remotely in travel status, went on a break in his personal car back to his hotel. When he was coming back to work, to the dispatch center, he was involved in a motor vehicle accident, and when the government was sued for that, government counsel said, no, you were on your break time, you're not on a one time, and so that's outside the scope, you weren't on employment. And that issue was litigated. Mr. Fowler had his attorney litigate that issue in the context of the civil litigation, and the court ruled he was within the scope of his duties, mainly because he was on an extended travel. He was on TDY, on an assignment, and they figured the employer should know he was going to take breaks during that time. And so this is really a marginal case. I wouldn't expect the result to always go this way, but to give you an idea of how far you can go and still be within the scope, here we had an individual who was on break time driving a personal vehicle to his hotel and was still found within scope. What if you're illegally abusing drugs or alcohol, right? So if I was agency counsel and I got a tort claim where an employee was illegally imbibing drugs or alcohol on duty, I would deny it, right? We don't hire you to do that. But that's not always the result. Here in Garcia versus U.S., the issue was litigated. Again, another instance of extended travel by an EPA law enforcement officer. He was drunk driving in a government vehicle after work hours. and was involved in an accident, injured some people, and his coverage was, of course, denied. But the U.S. eventually determined that he was within the scope. The plaintiff sued over that and was litigated in the court, and eventually it ended up the court agreed that he was within the scope of his duties because he was on official travel status, in a government vehicle, etc. So this shows you some limits of how far an employee can go. In this case, both criminal action and violating personnel policies by being drunk in a government vehicle, and still be within the scope of duties. Again, there are no case law examples within the scope of prescribed fire or wildfire, but I'm using these as analogies to show you how far you can go and still be within the scope. All right. So back to my initial 4 questions that people usually ask. Can I be sued? The answer to this is yes. You can always be sued for almost anything. That doesn't mean that the lawsuit will stick. It also doesn't mean that you will be held personally liable. Go back to this long, dry legal presentation I just gave you. Although you might be sued, if you're acting on behalf of the federal government, the supremacy clause kicks in. You may not be subject to state law. You might have absolute immunity for negligence. Okay, if your actions were negligent and within the scope of your duties, the government's liable, not you. You may have qualified immunity for discretionary actions. There must be negligence. Maybe it was an act of God that caused this damage. Better yet, for you as a government employee, if you are personally sued, the government might substitute themselves for you. There's a process for that, of course, a form. You need to certify to the Department of Justice that the employee was acting within the scope of their employment. And if that is the case, then the United States intervenes in the lawsuit, substitutes themselves for you individually, and is essentially saying, no, this lawsuit's against the government, not the individual employee. Finally, you may be entitled to agency representation. If you're sued for personal liability, the Department of Justice can represent you if you are within the scope of your employment, and representation is in the best interest of the government. Now, the way this normally works out is if you're within the scope of your employment, more commonly you're going to be substituted out and the department will intervene. But sometimes you do end up with an agency representation depending on the case. Finally, you can be indemnified. Let's say there's a question whether you're within the scope, you get a judgment, and afterwards it's determined that you were within the scope of your employment. Well, the federal government can indemnify you for actions within the scope of employment. Now, the regulation says the government may indemnify. I'm not aware of any situation where an employee was determined to be within the scope, but the government did not indemnify. If you've heard of one of those, feel free to send me a note, but that would be an exceedingly rare circumstance. Now, the next question I'm usually asked is, can I be held liable personally if I've taken actions while a federal employee? And to remind you of those situations, yes, if you act criminally or recklessly. Remember my example, driving 25 miles an hour over the speed limit, driving blindfolded, arson, where you're burning without a burn plan. Those are all actions where the federal government's not going to defend you, and you may be held criminally liable. If you lie to investigators, remember the beginning of my presentation about investigations. The single greatest reason why individuals are held personally liable in a criminal context is lying to investigators. If you violate a clear legal requirement or constitutional rights, it has to be very, very clear. Say an individual is entitled to benefits and you simply deny that for arbitrary reasons. Acting outside the scope. Again, that's very fact dependent, depends on state law, but it takes some effort, as shown by my examples of individuals driving drunk in government vehicles off official time, still being found within scope. It really takes some effort. You don't trip and accidentally fall out of the scope. Now, what I can say, I have not found any instance where a prescribed fire ignited by federal employees resulted in a personal liability suit against the individual, and certainly none that resulted in personal, civil, or criminal liability. Why is that? Because the government has the deep pockets. The plaintiff's attorney's primary motivation is usually to recompense the injured individual. That means you're going after the person with deep pockets. And usually that's the United States government, not you individually as a government employee. So generally what people are looking for is to find the government's liable and to fight through all those exceptions of discretionary function and sovereign immunity. Personal liability suits are very rare and usually involve some unique set of circumstances where the government cannot be held liable, but there's a potential for personal liability, such as a criminal act. So here is an example from a prescribed fire context that did not result in any personal liability, and that is the Cerro Grande fire. This is about as bad an example as I can think of. It started as a controlled burn, which was the correct terminology at the time, by the National Park Service on Bandelier National Park. It escaped. It burned 150,000 acres, hundreds of homes, including government property on Los Alamos National Labs. $1 billion in damages was the estimate. Every type of investigation I mentioned was conducted, except a fatality investigation, thankfully. There were multiple independent investigations, both by Department of Interior, congressional investigations, etc. The investigations part was not fun for any of the employees involved, but in the end, no one was fired. No one was held personally liable. No one went to jail. Some employees did receive reprimands, minor disciplinary action, requirements for further training. Some employees retired after this, but no one was held personally liable. And it gets back to a situation of, did they follow the burn plan? Were they within parameters? And what were the contributing factors, such as unforeseen wind events? And in the end, even if you argue there was negligence in Cerro Grande, well, that's the liability of the government, not individuals involved in this prescribed burn. To learn more about this, there's a staff ride, and it's used in an example in M582. If you want to watch a video, sort of an after action on the Cerro Grande fire, there's the whole video. You can click on the link here. I'll move my pointer to that link. That takes you through the events of that prescribed fire and what happened. It's worth your time. So I'm going to summarize some key points from the personal liability part of the presentation. There are exceptions where you can be held personally liable. Intentional criminal conduct, lying to investigators, recklessness. They are generally rare exceptions. For the most part, federal employees are shielded from individual liability because of the absolute immunity for negligence and the liability of the government for those actions. There are no instances where an escape prescribed fire resulted in personal civil liability. Now I'm going to talk to you about professional liability insurance. This is a common question I get, whether I should have professional liability insurance or not. This is something of an individual question. There's no right or wrong answer here, so I'm going to give you some pros and cons. Here's one of my favorite cartoons. This fellow is telling the judge that he thought he was guilty till his lawyer straightened him out on that. And, it's good to have your own lawyer. So here's how you can do that. Here are your options. You can obtain a specialized insurance policy. There are several carriers out there that specialize in selling professional liability insurance to federal employees. I will give you some contact information for those at the end of the presentation. You can also add it on an umbrella liability policy or homeowner policy. Most homeowners policies have an option for that. The government will reimburse 50% of the cost for supervisors and law enforcement officers. Of course, there's a form for that and a process. It usually takes a couple months to get the reimbursement, but I just renewed for a cost of about $300 and process my reimbursement and expect to get paid, here in the next few weeks, the half of that, the $150. It's only for supervisors and law enforcement officers. If you don't fall in that category, it's all out of your pocket and the government does not reimburse. A key point here, I'm pointing with a pointer on the bottom of slide 27, some policies are limited to legal counsel after the Department of Justice determines the scope of employment. Were you within the scope of your duties? Look for one that offers predetermination legal counsel. I'm going to give you 3 options at the end of the presentation. Here are some pros and cons. It costs a couple $100 a year, but you get half that reimbursed by the government. You're never going to use it. Those are the odds. You're just probably never going to use it. But I haven't used my homeowner's insurance. I haven't used my life insurance. I still have those in case. And, if you're one of the unlucky few, you might be happy you have it. There will be coverage exclusions, all right? They're not going to cover criminal conduct, reckless conduct, sort of things that you consciously knew and accepted that you should not be doing. Here's the positive side. The most common use is for personnel issues. Don't worry about prescribed fire. If you're a supervisor, you need this for all the disciplinary actions and personnel actions you're going to take, the grievances and harassment claims. The vast majority of instances of exercise of personal liability policies are related to these personnel issues. It can provide legal services for some investigations and during the time before Department of Justice determines whether you're within the scope. Now, you would think determination of whether you're within the scope of your duties would be a quick, easy determination. You're on official time, etc. Most cases I've dealt with, it was a simple, perfunctory determination, quick and easy and obvious within the scope determination by Department of Justice, and happened before any real costs were incurred in litigation where an employee was named. I have seen 1 or 2 instances where the determination on scope took months. These are the borderline instances where there are bad facts, where it's not clear if this is just gross negligence or maybe there was some intentional conduct here, perhaps criminal conduct. Where it takes a long time to make that determination, that is where professional liability insurance could assist you by providing counsel during that interim time while Department of Justice is figuring out whether it really wants to defend you or not. Finally, it's nice to have your own lawyer because the agency lawyer is not your lawyer. This is the first thing I always did when I was an attorney for the agency is explain to employees, I'm the government lawyer, not your lawyer. If we come upon facts that indicate you're, acting inappropriately, there may come a time where we have to part ways because I represent the interests of the government, not your interests. And, sometimes it's nice to have your own lawyer to advise you on things. Is this defense that the government taking really the the right defense? Should they be saying it's all my fault, I was grossly negligent? Do we agree with that? Again, back to one of my favorite cartoons here on slide 28. He is a sleazy lawyer, but he's my sleazy lawyer, and sometimes it's good to have your own lawyer. So to summarize here, there are pros and cons. I know many professionals involved in prescribed fire and wildland fire who've never had personal liability insurance for their entire career and never had a reason to use it, and consider that it's a waste of money because the government's going to defend you, and there's no need for it. And I know many people who are very happy with that approach. On the other hand, there are those few horror stories where people really wish they had it or had used it. So it really is a personal preference. It's up to you. Here are the main pros and cons. So I'm going to summarize just a couple key points from this entire presentation on liability investigation. If you just remember 4 things out of this whole presentation, here are the 4 things I want you to take away. Number 1, documentation. Have a plan. Use it. Document the important events. If you don't document, it didn't happen. Documentation is your friend in any investigation or liability situation. Don't ever lie to investigators, civil or criminal, or as a witness, or really ever. That is the most likely reason you would get yourself in trouble. It's always easier to defend a not-so-great fact than it is a lie. Stay within the scope of your employment. It's really not that hard to stay within the scope of your employment. It really takes some conscious effort to do something you should not be doing, to go outside the scope of employment. So don't take those unnecessary risks. Finally, consider professional liability insurance. It may or may not be the right fit for you, but I'll give you some companies that you can contact if you're interested. Don't take my word for it. Here are a number of scholarly articles. If you end up talking with your legal counsel about this, or if you're a lawyer yourself and you want to learn more about this, here are 3 law review articles talking about these very same topics that I talked with you about today. The citations are there, along with the Department of Justice manual on tort litigation when they would defend employees and when the United States is liable, etc. There is a link here I will point to with my green pointer. Trainings I would recommend if you're interested in learning more about these issues. You will not stand alone. This is one of the best trainings I've taken in my life. This is how to help your employees mentally, financially, and administratively if there is a bad outcome, either a serious injury or fatality. It is a multi-day course, and I recommend it for all agency administrators to take. M582, Advanced Agency Administrator, they will talk about some of these issues during that course. And finally, a couple personal liability insurance carriers. I do not advocate on behalf of these individual corporations, but what I can say is I know individuals who have their insurance, all 3, and at least the last version of the policies I looked at, they all had predetermination legal representation, so you could get some early legal advice if Department of Justice delays in making that scope of duties determination. So here are the names of websites for those 3 companies. Price point is all very similar, within $300 to $500 range, depending on the amount of liability coverage you get. So that concludes my presentation.